The file opens on a date the city liked to repeat to itself, July 4th, 1827, New York. In the official chronology, it is a clean line, the final end of slavery in the state, the last step of a gradual abolition written into statute decades earlier. The language of the law is almost ceremonial, an emancipation that arrives on the nation's birthday, as if freedom must always borrow legitimacy from a flag and a holiday. Clerks mark it in ledgers. Ministers reference it from pulpits. Newspaper columns in Lower Manhattan print the date the way a government prints a new boundary. But the city's paper victory does not mean the city has stopped practicing captivity. The same weeks that celebrate emancipation also preserve old reflexes. Landlords who refuse black tenants, employers who keep wages low with a shrug, policemen who patrol black bodies as if the ink in the statute has not dried. If slavery has ended on paper, it has not ended in habit. A free person can still be treated as a trespasser. The first tension in this story is not a confrontation on a streetcar. It is a contradiction built into the everyday. Freedom recorded, equality withheld. In the years after 1827, the city grows louder and more crowded, and it learns to move differently. The streets are the same, Pearl Street, Chatham Street, Broadway, but they thicken with commerce and with a new confidence. People in New York begin to measure their lives by access to work, to churches, to schools, to the markets, to the ferries, to the new engines of mobility that promise to compress distance into a fare. There are records that suggest a kind of order. City directories listing heads of household, church registers recording baptisms and marriages, census schedules arranging human beings into columns. When black New Yorkers appear in those documents, they appear in clipped labels: colored, mulatto, servant, laborer, as if identity is an administrative problem. These pages do not describe fear. They do not register humiliation. They only confirm that someone existed long enough to be counted. And yet the body remembers what the page does not. A free black child can learn early what it means to be watched. She learns it in small refusals, the shopkeeper's delay, the driver's decision to tighten his grip on the reins as she passes, the tone a clerk uses when asking her father's name. She learns it in the geography of the city, which doors are safe, which doors are tolerated, and which doors become dangerous when night falls. Somewhere in this post-emancipation New York, Elizabeth Jennings enters the world, born into freedom but not into ease. The official documents that later attach to her name do not narrate her childhood with tenderness. They place her within a family and a neighborhood and a city that are already arguments. She is raised under the shadow of two competing stories. The first story is the one the city tells about itself, that New York is a modern place, a commercial capital, a site of progress where slavery has been abolished and opportunity is open to those who work. This story is supported by the appearance of institutions, churches, schools, associations, by the steady accumulation of paperwork that suggests stability and legitimacy. The second story is quieter and harder to file. It is the story of free black New Yorkers who understand that legal status is not social permission. Freedom is not an invitation. It is merely the absence of one specific chain. The city has learned to replace the chain with rules, rules that are rarely printed as law, but enforced like law. Rules administered not by judges but by conductors, landlords, employers, policemen, men whose authority is carried in their tone, their posture, their ability to call another man with a badge. Elizabeth's father, Thomas L. Jennings, appears in the record as a man who refused to accept the city's limits as final. He is remembered as a skilled tradesman, someone who could stitch and cut and build a life with precision, and as a man connected to the black civic world that held itself together through churches and mutual aid. In one version of the official story, this is proof that freedom works. A respectable black household, a father of accomplishment, a family aligned with reform, as if respectability could purchase safety. But the reality that family lives with is that respectability is also a demand. It is a tight collar worn for survival. In public, your behavior must be beyond reproach because your mistake will be treated as a verdict on your entire race. A free black woman is made to carry more than her own dignity. She is made to carry the city's suspicions and then politely disprove them. By the 1830s and 1840s, the city's movement becomes more systematized. Horse-drawn streetcars begin running on tracks, and the promise is simple. Pay a fare and you may cross the city in relative comfort. It is a modern technology wearing an old logic. The cars are privately owned, and private ownership becomes a shield behind which exclusion can masquerade as management. On paper, the streetcar is a service. In practice, it becomes a gate. The rule is often presented as common sense. Certain passengers may ride, others may not, or may ride only under conditions. Sometimes the justification is order, sometimes comfort. Sometimes the phrasing is vaguer, company policy, custom, the way things are done. Officially, no one has to say segregation for segregation to function. The city does not always need a statute to enforce a hierarchy. It can rely on the public's willingness to accept humiliation as normal. Elizabeth grows into a young woman within this machinery. She is educated. She belongs to a Black community that values literacy because literacy is both defense and weapon. She learns what it means to stand inside institutions that keep minutes, preserve petitions, file complaints. She learns the language of improvement and moral reform, but she also learns the price. To insist on rights, you must speak in the dialect the law will recognize. The law, however, is not neutral paper. It is a room. It is a set of faces. It is an atmosphere. There are nights when the city's promises feel especially thin. Night in New York is not merely darkness. It is the moment when a person's safety is determined by how quickly help will arrive, and whether that help will recognize you as worth protecting. For Black New Yorkers, night carries a particular tension: the fear of violence that no one will prosecute, the fear of accusation that no one will question, the fear of being treated as guilty simply for being present. This is the background that makes an incident on a streetcar more than an argument over seating. By the time Elizabeth Jennings is old enough to move through the city alone, she has already learned how power works in public spaces. It speaks calmly, it invokes rules, it expects compliance. It does not need to shout to be dangerous. In the official version of New York's story, the city is moving forward. The archive shows expansion: more routes, more commerce, more institutions, more notices printed in neat columns. The city presents itself as a place where everything can be documented, and therefore everything can be made orderly. But in the reality Elizabeth lives, order is selective. The paper record is not an even table. It is a tilted surface, and certain people must brace themselves against it every day. Some names and places begin to gather around her future like loose pages waiting to be filed. Pearl Street, Chatham Street, Sunday morning, a church service, a fare paid, a refusal delivered as policy. None of it has happened yet in this part of the story, but the system is already in place. The rules are already rehearsed. The city has already decided in countless small interactions who belongs and who must be reminded again and again that belonging can be revoked at any moment. Elizabeth Jennings grows up in the space between what the city claims and what it does, between emancipation and exclusion, between ink and flesh. And in that space, a case is forming before anyone calls it a case, quietly, relentlessly, the way a bruise forms under the skin, proof of contact, proof of force, proof that something happened even when the official record has not yet found the words. Part 2. Private Rails, Public Humiliation, New York in the early 1850s. New York in the early 1850s is a city learning to accelerate. The official record describes it in the language of improvement. New routes, new companies, new ordinances, new schedules posted in print. The city's movement is no longer only a matter of legs and weather. It is organized by timetables, fares, franchises, and the quiet authority of corporations that begin to treat the streets as usable property. There are signatures at the bottom of charters. There are notices in newspapers announcing extensions of lines, changes in service, rules for the comfort of passengers. The city reads these notices the way it reads weather, as ordinary, as inevitable. But the street does not become neutral simply because a rail is laid into it. A horse-drawn streetcar is a small room dragged through the city. Benches, windows, a narrow aisle, and the conductor's presence as a moving gatekeeper. A fare is paid. A bell is rung. A stop is made. All of it looks orderly, even merciful, compared to the chaos of omnibuses and crowded sidewalks. The car promises something close to dignity: a seat, shelter from rain, a faster path to work or worship. That promise is the surface. Underneath it is a different ledger: who is permitted to sit and who is expected to stand aside, who is treated as a customer and who is treated as a disturbance. The companies rarely need a law printed in the statute books to accomplish this. They rely on a more flexible tool: policy. Company policy is a phrase that sounds administrative, almost harmless. It is not the voice of a judge, it is the voice of a man on a platform, holding a strap, deciding whose presence counts as acceptable. It is the power of private business applied to public life. The company owns the car, the company employs the conductor, the company frames exclusion as management rather than violence. In an archive, the policy appears as fragments, a printed rule sheet in a corporate file, a line in a newspaper report, an instruction remembered in testimony, a complaint written as a letter that will later be folded, filed, and forgotten. The policy is not always consistent across routes or companies. That inconsistency is part of its strength. If you cannot point to a single statute, you cannot easily argue against it. You are left disputing a custom that pretends it is natural. On paper, New York is a free state. By the 1850s, that fact is repeated with pride in respectable circles. The city's political class likes to compare itself to the South, to suggest a moral distance measured in latitude. There are speeches that praise New York's modernity. There are editorials that describe the city as a beacon. But Black New Yorkers understand the difference between a free state and a free life. They have learned that the city's institutions can be both real and evasive, real enough to count you when it benefits them, evasive enough to refuse you when it costs them. They also understand something else, something the official record rarely admits. Mobility is not merely convenience, it is power. The ability to move without being questioned is a form of safety. The ability to arrive on time is a form of dignity. The ability to ride rather than walk is a form of social permission. In the early 1850s, as streetcars multiply, permission becomes visible. It is measured in inches of bench space. The newspapers, when they mention such matters, often do so in tones that treat humiliation as public theater. A black passenger forced off a car can be written up as an item of disorder, an anecdote about a conductor maintaining discipline. Some papers adopt a moral posture, sympathetic in principle but careful in language, unwilling to offend readers whose comfort is treated as the city's priority. Other papers are openly hostile, describing black riders as provocations, as if the mere request to be carried is an act of aggression. This is the official story as it hardens. The company must protect respectable passengers. The conductor must prevent disturbances. The public must be reassured that order is being kept. The lived reality, however, is not a disturbance. It is an injury performed in public. The car arrives, the door opens, the conductor sees a face and makes a decision before a word is spoken. Sometimes the decision is delivered politely, as if politeness changes what it is. Sometimes it is delivered with contempt. The passenger may be told to wait for a colored car, if such a thing exists on that line, or to take an omnibus, or to walk. The instruction is always framed as reasonable. The reasonableness is the cruelty. It asks the excluded person to participate in their own erasure calmly, without making the city uncomfortable. If the passenger refuses, the mechanism becomes physical. Not always with fists or clubs, but with hands that seize and pull, with a body made into an object to be removed. Even when the force is minimal, the meaning is maximal. You are not here by right. You are here by tolerance, and tolerance has been withdrawn. The early 1850s are full of these small scenes, most of which never become formal cases. They vanish because the victims calculate the cost of resisting. A complaint requires time, money, and witnesses willing to speak. It requires faith in a court that may see your dignity as negotiable. It requires walking back into the city's machinery and asking it to acknowledge that it harmed you. For many, survival is quieter. They endure. They avoid certain lines. They travel in groups. They leave earlier and walk farther. They learn which conductors are less strict, which routes are less hostile, which hours are safer. They trade information the way a besieged community trades maps. The archive does not preserve these calculations well. It preserves outcomes, not the daily arithmetic of fear. Within Black New York, there are institutions that try to hold the line against this erosion. Churches record membership in meetings. Ministers speak of dignity not as abstraction but as defense. Mutual aid societies keep minutes, collect dues, arrange support for families damaged by illness or unemployment or sudden crisis. Community leaders compose petitions and statements, using the language of citizenship as both shield and blade. The paper they produce is earnest and disciplined because they know how quickly their grief can be dismissed as disorder. Elizabeth Jennings grows into her young adulthood in this environment, where the city's modern conveniences are also modern instruments of exclusion. Officially, she is free. She is not a fugitive. She is not property. That should mean something. It means something in the law's self-congratulation. It means little on the streetcar step when a conductor decides the car is not for her. The city, meanwhile, continues to build. Streets are repaved, businesses expand, the harbor traffic thickens, timetables become more precise. The promise of speed becomes part of the city's identity. People begin to speak as if movement is a right purchased by ambition. But ambition does not buy black passengers the same protections. A fare in the hand does not guarantee a seat. A church appointment does not guarantee passage. A respectable appearance does not guarantee dignity. The very concept of respectable is weaponized. If a black rider is turned away, it is said to be because she is not respectable enough. If she is respectable, then her presence is said to threaten the comfort of others. The logic is circular and airtight. It is built to prevent any outcome that resembles equality. In the official narrative, there is no crisis. There are only policies, only company decisions, only the ordinary management of public space by private owners. The city will later claim it did not legislate segregation here, as if that distinction absolves it. In the reality experienced by black New Yorkers, segregation is not less real because it is privately enforced. In some ways, it is more intimate, more immediate. It happens at arm's length, in the doorway, in the conductor's gaze. It is delivered without ceremony, without a courtroom, without the formal dignity of accusation. Only the blunt fact of exclusion. By the time the calendar turns toward the middle of the decade, the conditions for a confrontation have been prepared. The rails are in the street. The policies are understood. The newspapers know how to frame a black refusal as disruption. The police know which side of the platform they are expected to stand on. The courts, if called upon, will be asked to treat this as a technical matter, a company's discretion, a passenger's behavior, a question of order. What the community knows, even before the case exists, is that it is a question of personhood, and somewhere in that city of schedules and quiet humiliations, Elizabeth Jennings is moving toward a morning when she will be late, and the city will demand that she accept the punishment of being made late forever. Part 3. Sunday, July 16, 1854. The Refusal, Pearl Street and Chatham Street. Sunday mornings in New York carry a particular kind of discipline. The official city is quieter than it is on weekdays, but it is not at rest. Bells begin early, doors open and close with care, streets fill in measured waves, families walking toward churches, men in clean coats, women holding gloves or hymn books, children trained to keep pace. The city's moral self-image appears most clearly on Sundays, orderly, respectable, confident in its own righteousness. For black New Yorkers, Sunday can feel like a narrow corridor of safety. Church is not merely worship, it is an institution that keeps names, records, and minutes that can confirm a person's standing when the city tries to deny it. It is a place where dignity is spoken aloud. But even on Sundays, the city's hierarchy does not take a day off. Respectability is still demanded, and it does not guarantee protection. On July 16, 1854, Elizabeth Jennings is moving through this Sunday city with urgency. She is late for church. The lateness matters because in a world that already questions her legitimacy, lateness can be used as a pretext. Late people are careless, late people are disorderly, late people are suspect. She is not careless. She is simply human, caught in time the way every person is caught in time. But she knows the city will not grant her the ordinary mercy it grants others. Her clothing, according to later descriptions, is proper for worship. Nothing about her appearance is designed to provoke. She is a young black woman, free-born, educated, raised in a community that understands the cost of being perceived as improper. She carries herself as someone who has learned that posture can become testimony. The city reads bodies before it hears words. She reaches the corner of Pearl Street and Chatham Street, a space of movement and commerce even on a Sunday. The streetcar line there is part of the city's promise, a way to cross distance with less strain, to arrive on time, to participate in the city's rhythms rather than being forced to orbit them from the margins. The streetcar arrives, the platform is there, the door is there. In the official story, this is where the transaction should be simple. A passenger boards, pays, rides. That is the fiction of public service. Elizabeth steps onto the car. The refusal does not begin with raised voices. It begins, as these things often do, with a man performing authority as if it is merely routine. The conductor notices her and responds with the practiced language of policy. The exact wording shifts across later accounts. Policy is always slippery when it needs to be defended, but the meaning is consistent. She is not welcome. In the official version that will later circulate, the conductor is simply enforcing rules. The company's right to regulate its own property is treated as self-evident. The comfort of other passengers is implied. The possibility of disruption is invoked as a justification before any disruption has occurred. But the reality Elizabeth experiences is more direct. She has paid the fare. She has presented herself as any other worshiper might, and she is being told that her presence itself is the problem. She refuses to leave. This refusal is not theatrical. It is not a speech. It is the simple, stubborn insistence that a free person who has done nothing wrong should not be expelled from a public vehicle because of race. It is a refusal that forces the system to reveal itself. A quiet compliance would have allowed the policy to remain invisible, another Sunday humiliation absorbed and forgotten. Her refusal makes it visible, and visibility makes institutions nervous. The conductor escalates. His authority is limited to the car, but the car is moving through the city's social order like a small extension of the state. He cannot tolerate a precedent forming in the aisle. If one black woman can remain, then the policy is not policy, it is preference. And preference is harder to defend. He attempts to remove her. This is the moment the archive will struggle to capture cleanly, because violence in public is often described in euphemisms by those who benefit from it. In later retellings, there will be phrases like forcibly ejected or removed. Such terms are administrative. They sound like procedure. They are designed to make physical domination sound like maintenance. In reality, a body is seized. Balance is disrupted. Clothing is pulled. The act is intimate in the most humiliating way. Strangers' hands claiming authority over her body. The car's narrow space turning into a stage where dignity is contested. The passengers are witnesses, but their witnessing is uneven. Some look away. Some watch with interest. Some align with the conductor's authority because that alignment is part of their own security. Elizabeth does not cooperate with her own removal. The refusal becomes physical because the system insists it must become physical. She holds her place. She resists not as an attacker but as a person refusing to be treated as luggage. The struggle draws attention beyond the car. The street becomes involved. Someone calls for police. When the police arrive, the official narrative gains its most powerful reinforcement. A private company's discrimination can be framed as legitimate when an officer stands beside it. The presence of the police transforms policy into something that looks like law, even when the law itself is ambiguous. The officer does not need to cite a statute. He only needs to treat the company's demand as reasonable and her refusal as disorder. The policeman intervenes. Here, again, the difference between official record and lived reality widens. The official record prefers to describe police intervention as restoration of order. The police are present, in that story, to prevent chaos. But the reality Elizabeth experiences is that the state's muscle is being used to force her back into the city's assigned place. The police do not arrive as neutral arbiters. They arrive already trained to recognize whose complaints constitute a threat. Elizabeth is removed from the streetcar. What remains is not only the fact of expulsion, but the aftermath in the body. The shaking hands, the rawness of public exposure, the lingering sense that the city can touch you and then deny it touched you. The official story will later reduce this to a dispute over rules. Her body will remember it as a violation. She is late to church now in a different way. The lateness has turned into something heavier than missed minutes. It is the awareness that even worship is not protected from the city's exclusions. The streetcar has become a courtroom without walls, and the verdict has been delivered by force. But this is not the end of the morning. The crucial turning point is what happens next. She does not let the incident evaporate into private pain. In many cases, humiliation remains unfiled because the filing itself is dangerous. To complain is to risk retaliation. To complain is to invite public scrutiny. To complain is to face a system that often uses your complaint as evidence against you. Proof that you are difficult. Proof that you do not know your place. Proof that you are, in some undefined way, a problem. Elizabeth does not retreat into silence. Her family and community will soon begin the process of translating what happened into something a court can hear. That translation is itself an injury. It requires taking a lived experience of humiliation and fitting it into legal categories. It requires identifying witnesses, reconstructing time and place, naming individuals who may deny what they did, describing force in language that will be deemed acceptable. It requires understanding that the law is not an instrument of empathy, it is an instrument of classification. Already, the competing narratives begin to form. The company's version will emphasize order, policy, discretion. The newspapers sympathetic to the company will frame Elizabeth as an agitator or an inconvenience, as if her insistence on riding is more disruptive than the violence used to stop her. The police, if asked, may describe her as uncooperative, as if cooperation with discrimination is a civic duty. Elizabeth's reality is simpler and more severe. She tried to ride like any other New Yorker, and she was punished for it. The file begins to open on that Sunday. It opens in the space between Pearl Street and Chatham Street on the step of a streetcar, in the moment a conductor decided that a black woman's presence was negotiable. It opens when police power was used to enforce a private exclusion. And it opens because Elizabeth Jennings refused to let the city's policy remain invisible. What is still uncertain, at the end of this part, is whether the city will allow that file to exist as more than rumor, whether it will permit the incident to become evidence, whether a courtroom will be forced to listen to what happened on a Sunday morning when a woman tried to reach church and instead found the machinery of segregation waiting for her at the door. Part 4. The morning after. Church, community, and the first draft of the story. The next day does not erase what happened on the streetcar. It clarifies it. In the official rhythm of New York, a Sunday incident should dissolve by Monday morning into the noise of commerce. The streetcar lines resume their schedules. Conductors resume their routines. Passengers return to work and errands and forget what they witnessed, or pretend to. The city prefers forgetfulness because forgetfulness keeps policy clean. It keeps the rails smooth. It keeps the illusion that order is natural. But for Elizabeth Jennings, the morning after is not ordinary. It is the first moment when the injury is no longer only physical or private. It becomes a question. Will this be allowed to become a record? The body carries its own testimony, soreness, fatigue, the lingering tremor that follows a public struggle. But bodies do not enter courts on their own. They must be translated. They must be interpreted by words, signed by witnesses, fixed into the grammar of complaint. The system that harmed her now demands that she speak in its language if she wants recognition that harm occurred. The first place where that translation begins is not a courthouse, it is the community. On Sunday, she had been trying to reach church. The irony is not lost on those around her. A city that claims moral superiority forces a young black woman into confrontation precisely when she is attempting to worship. Church in Black New York is not simply a building, it is a shelter of legitimacy, an institution that understands how to preserve names and reputations when the wider city treats them as disposable. Church keeps records because records are survival. When Elizabeth enters that space, whether late, shaken, or bruised, she does not enter as a lone figure, she enters into a network. The people who see her are not strangers, they are members of a community that has learned to read the city's small aggressions as part of a coherent system. What happened on the streetcar is not new in type, it is new in clarity. The conversation begins quietly, because trauma often begins quietly. People ask what happened, she answers. They ask for details, where, when, which line, which conductor, who else was present. This is not curiosity. It is the beginning of documentation. The first draft of the story is being shaped by necessity. Already the tension appears. The community wants the truth, but it also knows the law will only accept a version of truth that is legible to power. If Elizabeth speaks with anger, she may be labeled irrational. If she speaks with too much composure, she may be dismissed as unaffected. If she describes force, she must do it without sounding improper. If she describes humiliation, she must do it without appearing to accuse the city itself. The law offers narrow channels for black testimony. It prefers black suffering to be quiet, contained, and framed as a problem to be managed rather than a wrong to be corrected. In these early hours, the community begins to decide what to emphasize. They will emphasize that she is respectable, that she was on her way to church, that she paid her fare, that she complied with the ordinary expectations of a passenger. This is a strategic choice. It is not that poor or uneducated black riders do not deserve justice. It is that the city is more likely to listen when the victim resembles the city's own moral ideal. Respectability becomes evidence because the city has made it necessary. Her family is central to this effort. Thomas L. Jennings is not merely a father, he is a man familiar with civic process. He understands petitions, meetings, committees, the scaffolding through which power can be challenged without being immediately crushed. He also understands something more intimate. His daughter's experience is not only a personal violation, it is a public message. The message is meant to travel. Black riders will be removed even on Sundays, even when properly dressed, even when they pay, even when they do not provoke. If that message goes unanswered, the companies will treat silence as permission, so the response is organized. In the days after July 16th, the incident begins to circulate through Black New York in the form of conversation, then statement, then plan. Meetings are convened, names are taken down, potential witnesses are identified, people who were on the car, people who saw the removal, people who heard the exchange. This is careful work because witnesses are fragile. A white witness may refuse to be involved. A black witness may fear retaliation or disbelief. A policeman may rewrite his memory into official phrasing that protects his actions. The community understands that the first battle is not in court. It is over narration. The company's version will be prepared quickly. It will likely be simple. A passenger refused to follow instructions. The conductor attempted to enforce rules. Order required removal. The police assisted. This narrative has the advantage of familiarity. It sounds like hundreds of other small incidents that the city has accepted without question. Elizabeth's version must be built against that familiarity. It must insist that what happened was not an unfortunate misunderstanding but an unlawful act. It must claim explicitly that a free person was denied a public accommodation and then assaulted when she refused to accept that denial. But even within the community, there is tension over how hard to press. Some will fear that open confrontation invites backlash, not only from the company but from the public. There is always the possibility that the press will turn hostile, that the courts will refuse, that the company will retaliate by tightening its exclusions. There is also the psychological weight of exposure. To bring the case forward is to bring Elizabeth forward, to place her name and body under scrutiny. The city's cruelty is not only physical, it is also the process of making victims stand still while their suffering is examined. Elizabeth's family must decide whether to allow her to become that figure. If they do nothing, the humiliation remains hers alone. If they act, the humiliation becomes public, and public humiliation is a second ordeal. The choice is not between pain and no pain. It is between two forms of pain: private injury that changes nothing, or public injury that might. The first draft of the story is written with these constraints in mind. In community discussions, the details are rehearsed: the location, the car line, the time of day, the conductor's words, the point at which the police became involved. Each detail matters because details become anchors. The more precise the account, the harder it is for the company to dismiss it as rumor. This is where the atmosphere of paper begins to thicken. Notes are made, letters are drafted, meetings are recorded. A free black woman's Sunday is converted into an outline that can travel to an attorney's desk. The language shifts. The event is no longer only what happened to Elizabeth. It becomes what the company did, what the officer did, what rights are being denied. In the newspapers, the incident begins to take shape in a different way. Even sympathetic reporting is constrained by the editorial sensibilities of the time. Papers may describe Elizabeth's resistance as obstinacy or determination, depending on whether they want to praise or condemn her. They may emphasize the novelty of a young woman resisting removal, turning her into a moral tableau. Some may treat it as a curiosity, a colored female in conflict with a conductor, as if the primary point is that such a person dared to resist. The press becomes a second courtroom, and it is often harsher than the first. In this press courtroom, Elizabeth is not simply a passenger. She is a symbol people can use. For those who support segregation, she becomes evidence that black riders are troublesome. For those who oppose it, she becomes evidence that discrimination is brutal and irrational. Neither side is fully interested in the interior reality: the fear, the shock, the aftertaste of hands on her body, the sense of being displayed. The community, therefore, becomes the most reliable keeper of her humanity. In their meetings and conversations, she is not an abstraction. She is a person they know. That knowledge provides moral gravity, but it also adds pressure. She must remain strong, composed, exemplary. The city is eager for any sign it can use to discredit her. This is the psychological tension that builds across the days after the incident. Elizabeth must endure not only what happened, but the demand that she narrate it in a way that satisfies everyone else. The file continues to open. A lawyer must be chosen. A legal theory must be identified. The question is not only whether the company's conduct was offensive, it clearly was, but whether it was actionable, whether the court can be forced to treat a streetcar as something more than private property. The community begins to speak in terms that are both moral and technical: rights, public conveyance, common carrier, damages. These words are cold, but they are the words that can convert outrage into judgment. As this part closes, the incident is no longer a single struggle on a platform. It has become a structured conflict between two kinds of authority. On one side, the company's authority, private ownership dressed up as public service, enforced by conductors and backed by police. On the other, the community's authority, a moral claim to citizenship, supported by meetings, records, and the disciplined insistence that a free person is not a guest in her own city. The morning after becomes the first act of resistance, not because anyone has yet spoken in court, but because the community refuses to let the city decide what the incident really was. They begin to write it down, and once something is written down, once ink fixes it into a form that can be carried, quoted, filed, the city can no longer pretend it was only a moment, only a misunderstanding, only a disturbance that vanished with Sunday's last bell. It is now a case in formation, built out of paper and resolve, moving toward a courtroom that will be asked to choose between policy and personhood. Part 5. Building a case. Common carrier doctrine versus company rights. A lawsuit does not begin with a gavel. It begins with paper laid flat on a desk, and a question spoken quietly as if it might break something. What exactly is a streetcar? The companies want a simple answer. A streetcar is private property, a vehicle owned by shareholders, managed by officers, staffed by employees. A moving room in which the rules are set by the owner, enforced by the conductor, and protected, when necessary, by the police. In this official framing, the street is public, but the car is not. You may stand on the street and watch it pass. You may pay a fare if you are acceptable, but you cannot claim the car as a right. Elizabeth Jennings and the community around her need a different answer. They need the streetcar to be something more than a private room dragged through public space. They need it to be a public service, something that invites the public and therefore accepts public obligation. They need the company's discretion to have limits. This is where the language turns technical, and the technical language turns moral. In the legal tradition, there is a concept that seems at first glance almost dry: the common carrier. It is a doctrine shaped by commerce and movement, ferries, coaches, railroads, entities that make money by holding themselves out to the public. The promise is implied: if you serve the public, you do not get to pick and choose among orderly customers on a whim. You can set reasonable rules for safety and order, but you cannot turn a public service into a private club. The doctrine sounds like principle. In practice, it is a battleground, because if the streetcar is treated as a common carrier, then the company's policy is no longer merely policy. It becomes a potential violation. The car becomes a place where a fare is more than a coin. It is a contract. The refusal becomes more than humiliation. It becomes an actionable wrong. But courts do not live in doctrines alone. They live in the world. And in the world of 1854 New York, black riders are not assumed to be rightful customers. They are assumed to be exceptions, tolerated, managed, or removed. The law may not say segregation in clean statutory language, but the city practices segregation through habit, through custom, through the quiet consensus of those who benefit from it. So building a case requires more than naming a doctrine. It requires building a narrative that the court can bear to recognize. The file grows heavier. A complaint has to be drafted. Names, dates, locations, actions described in sentences that look calm even when describing force. The incident must be made legible. On Sunday, July 16, 1854, becomes the opening line of a new kind of record, one that refuses to allow the event to remain rumor. Pearl Street and Chatham Street become coordinates not for memory but for jurisdiction. The Third Avenue Railroad Company becomes not a faceless system but a defendant. In the official view, this is already distasteful. Companies prefer disputes to vanish without paperwork. Paper creates precedent. Paper creates scrutiny. Paper has a way of outliving the people who wrote it. The defense, even before it speaks, has its outline ready. It will argue that the conductor acted within authority, that the company's rules exist to preserve order, that Elizabeth Jennings created a disturbance by refusing instructions. It will imply that the company, like any private enterprise, must protect its other patrons. Patrons whose comfort is treated as a legitimate interest even when that comfort is built on exclusion. Comfort is one of the most efficient words in the vocabulary of segregation. It sounds gentle, it sounds reasonable, it disguises its own violence. It allows the company to describe discrimination not as hatred, but as management. Elizabeth's reality, her body seized, her dignity stripped in public, must be forced into a legal form that can stand against that word. The process is painstaking. Witnesses are approached. Some refuse, some agree, but with caution. Others cannot be found. A city is large, memory is fragile, fear is persuasive. A witness who is black may fear retaliation, employment threatened, housing made uncertain, harassment that will not appear in any official record. A witness who is white may fear social consequence or may simply not care enough to step into court. Even the police presence complicates things. In the official narrative, the involvement of an officer cleans the incident. If police assisted, then surely the removal was legitimate. That is the psychological function of state power in public disputes. It does not merely enforce, it validates. But from the victim's perspective, the police presence deepens the injury. It means that discrimination is not merely private preference. It is an exclusion with the city's muscle behind it. So the case must be built to counter the authority of uniform and routine. It must insist that police participation does not make a wrong right. There is another strategic tension, quieter but constant: how to describe violence without being discredited. A black woman who speaks too plainly about being handled and dragged risks being accused of immodesty, exaggeration, or hysteria. A black woman who softens the description risks having the court treat the incident as trivial. The law demands specificity, but the culture punishes black specificity. The case must thread this needle, detailed enough to prove harm, restrained enough to be believed. This is not an accident of the era. It is part of the system. The company's lawyers will likely present themselves as guardians of order. Their language will be clean. Their posture will be calm. They will treat the matter as an unfortunate disruption caused by an individual who refused to follow reasonable rules. They will speak of rights too: rights of ownership, rights of management, rights of private enterprise. The courtroom, even before trial, is already crowded with these competing notions of rights. Elizabeth's side must transform the humiliation into categories the law recognizes: assault, wrongful ejection, breach of the carrier's duty, damages. Money must be attached to injury because money is a language courts understand. Not because money is sufficient, but because money is how the legal system admits that something happened. This is one of the darkest bargains the law offers. To be heard, you must put a price on what should never have been taken. And then there is the larger fear, spoken rarely but felt everywhere, that the court will declare, explicitly or implicitly, that black people have no claim to equal access in the city's modern conveniences, that it will bless segregation by calling it reasonable, that it will turn exclusion into doctrine. This fear is not abstract. Courts have done it before and will do it again in other places. Law can be a weapon in either direction. It can expose a system's brutality, or it can wrap that brutality in legitimacy. So every draft, every affidavit, every meeting about strategy carries the weight of what could be established if they lose. The archive, meanwhile, becomes a battlefield of its own. The company will have its own records, employment logs, internal rules, perhaps notices posted to conductors. These documents, if they appear, will present exclusion as normal policy. They will not describe the violence required to enforce it. They will not record the fear in a passenger's throat when she realizes she is being surrounded. Corporate paper is designed to describe control, not consequence. Elizabeth's side will create a counter-archive, statements, recollections, a careful timeline. In this counter-archive, the city's ordinary cruelty is made abnormal by being named. This is how resistance often begins in bureaucratic societies, not with a riot, but with a file. By late 1854, the case is no longer merely an outrage in conversation. It is an instrument being prepared for court. Names are fixed. The company is identified as responsible. The events of a Sunday morning are organized into allegations that can survive cross-examination. The emotional cost of this work is real, though it rarely appears in the official record. Each retelling forces Elizabeth to revisit the moment of removal. Each step toward court turns her into evidence. She must hold her own story steady while others try to shake it loose. She must become, in effect, her own document, consistent, disciplined, defensible. The system is counting on fatigue. on embarrassment, on the common human desire to stop reliving what hurt you. But the community is counting on something else, the belief that a right not asserted becomes a right erased. In the official framing, this lawsuit will be treated as a dispute over property and management. In the lived reality of Black New York, it is a dispute over whether freedom has any practical meaning in public space. The rails run through the city like lines of commerce, but also like lines of power. The question that now approaches the courtroom is whether those lines belong only to those the company prefers, or whether the city's promises, written in laws and celebrated in speeches, must finally be honored where people actually live, in motion, in public, under the eyes of strangers. The case is being built not only to win damages, it is being built to force an admission that policy can be a mask, and that behind it there is a system deciding quietly and daily who is permitted to be treated as a person. Part 6. Culver, Parker, and Arthur, a young lawyer. An old system, early 1855. The courtroom is supposed to be the city's cleanest room. It is built for statements that can be checked, for records that can be stored, for procedures that can be repeated. Its furniture teaches a lesson. The judge elevated, the jury aligned, the counsel tables facing each other like opposing ledgers. In the official story, this architecture is proof of fairness. Everything has its place. Every voice gets its turn. The law is not supposed to be personal. But Elizabeth Jennings enters that room knowing that law is never only architecture. It is the people who occupy it, the assumptions they bring with them, the invisible agreements that shape what they consider reasonable. By early 1855, her case has moved from community meetings and drafts to formal litigation. It now requires attorneys who can navigate doctrine and procedure, who can speak the court's language without flinching, who can insist that a Black woman's experience is not a side issue, but the main fact. The firm involved, Culver, Parker, and Arthur, belongs to the city's professional world. Men in offices, men in coats, men trained to turn conflict into argument. Among them is Chester A. Arthur, still young, still building his reputation, not yet burdened by the future meanings his name will acquire. In the official version of this story, his presence can look like a comforting symbol, a rising lawyer, a professional advocate, a sign that the law can be persuaded. But Elizabeth's reality does not become safer because her counsel is competent. Competence is not protection. It is only a tool. The legal strategy in the open file is clear. The streetcar company is not merely a private host. It is a public carrier, operating on public streets, profiting from public movement. It cannot invite the public to pay and then exclude a portion of that public by racial preference. It cannot claim neutrality while enforcing a racial boundary. If the company is allowed to do so, then the city's emancipation is revealed as cosmetic, freedom of status with no freedom of access. The defense, too, is predictable. It will describe the streetcar as private property. It will describe the conductor as an employee acting within authority. It will describe the removal as necessary. If it must mention race at all, it will treat race as incidental, a factor in custom, in passenger comfort, in the maintenance of order. It will avoid moral language and instead frame discrimination as practicality. This is how systems preserve themselves, by converting injustice into routine. When the matter comes before a judge, the official setting insists that the case is simply facts and law. Yet the psychological reality is that Elizabeth is being asked to prove her humanity under conditions designed to doubt it. Even her demeanor can become evidence. If she appears too composed, it may be taken as proof she was not harmed. If she appears visibly shaken, it may be taken as proof she is unstable. This is one of the quiet traps laid for Black witnesses. You must display pain, but not too much. Dignity, but not too much. Anger, but never in a way that unsettles those who control the room. A white male jury, typical for the time, will likely sit with the confidence of men who believe public spaces already belong to them. They have not had to ask whether they are permitted to ride. They have not had to treat a fare as a petition. To persuade them, the case must do more than describe cruelty. It must demonstrate that the company's conduct violated a rule the jury can imagine applying to themselves. This is where the law's coldness becomes both opportunity and threat. Cold doctrine can sometimes cut through warm prejudice if the doctrine is framed correctly. If the company is a carrier, it owes a duty. If it owes a duty, it cannot discriminate among orderly passengers. If it cannot discriminate, then what happened to Elizabeth is not merely offensive, it is illegal. But the same doctrine can also be warped. The defense will argue that the company's duty is limited, that it may set reasonable regulations. They will claim that excluding black passengers or confining them to certain cars is reasonable because it prevents conflict. They will take the existing prejudice of the city and offer it to the court as if it were a natural condition, like rain. In the official version, reasonableness sounds neutral. In reality, reasonable often means comfortable for those in power. The proceedings force Elizabeth's experience into an unnatural form. What happened to her body must be described without the body being allowed to fully speak. Words like forcibly removed appear, but the courtroom is not built to feel what force means. It is built to classify it: mild, moderate, excessive, justified, unjustified, provoked, unprovoked. The company will likely imply provocation, if not explicitly, then through emphasis. She refused to leave, she resisted, she caused delay. The law has a habit of treating resistance as evidence against the victim, as if a person must submit calmly to discrimination in order to deserve protection. This is an old logic, older than streetcars, older than New York's abolition date. It is the logic of discipline. You may be wronged, but only if you respond in a way that does not disturb the wrongdoer's world. Chester A. Arthur and his colleagues must navigate this atmosphere. Their arguments must be precise, their tone restrained. They cannot appear to be radicals. They must appear to be professionals insisting on established principles. Even sympathy must be delivered as procedure. This is one of the moral ironies of advocacy in such cases. The lawyers must speak calmly about something that should never have happened. They must treat a public violation as a matter of duty and contract. Their success depends on persuading the court that the company endangered order by excluding Elizabeth, not that the company endangered her soul by humiliating her. In preparation and in court, Elizabeth is forced to relive the incident repeatedly. Each retelling is a second exposure. Each question: where were you standing? What did he say? Did you strike him? Did you scream? Is a demand that she reopen a moment she would likely prefer to close forever. The official process calls this examination. The lived experience is closer to interrogation. Yet within this painful structure, something important happens. Her story is no longer only hers. It becomes fixed in the court's memory, in the clerk's notes, in the public account that may later be printed. The city's attempt to treat the incident as routine is challenged by the mere fact that it is being written down under oath. The courtroom's ink is indifferent, but it is durable. The judge, an embodiment of the official version, must decide whether the company's policy is legitimate. He must decide whether the streetcar is a private enclave or a public service. He must decide whether exclusion based on race is reasonable. He must decide whether a black woman's dignity has legal weight. For Elizabeth, these decisions are not abstract. They determine whether her freedom is meaningful beyond her own doorstep. There is another layer of tension that runs beneath the legal arguments: the city's broader politics. New York is a place where anti-slavery sentiment exists alongside deep racial hostility. Many white New Yorkers oppose slavery in the South while supporting segregation at home. They can imagine freedom as a distant moral ideal while rejecting equality as a local inconvenience. This contradiction is not a mistake. It is a design feature of Northern racism. In that environment, Elizabeth's case forces a confrontation. It forces the city to look at itself not as a beacon but as a place where a free black woman can be dragged from a public vehicle on a Sunday and then required to prove that the dragging mattered. In the official narrative, the legal system is poised to correct a wrong. In the lived narrative, the legal system is being asked to admit that the wrong exists. As this part closes, the case has not yet reached its final verdict. The room is still full of controlled voices. The lawyers are still arranging their arguments. The company is still hiding behind the clean phrase, "our rules." The jury is still being asked to imagine that the streetcar belongs to the public, even when the public has been carefully defined to exclude certain bodies. Elizabeth remains the central fact. She sits under the weight of the room's gaze, knowing that whatever happens will not end on this day. A verdict will be recorded. A precedent will be suggested. But the deeper question, whether the city will accept her as fully entitled to move through it, will continue to echo beyond the courtroom's walls. The law is about to speak, and like all official speech, it will attempt to sound final. Part 7. A wholesome verdict. Damages, costs, and the price of being right. When a jury returns, it does not return only with a decision. It returns with a number. In the official mechanics of the court, this is considered resolution. Wrongdoing is acknowledged, and the acknowledgement is converted into damages. The law prefers quantities because quantities can be filed, they can be compared, they can be paid, they can be closed. A verdict written in figures looks clean on paper, even when it is born from a dirty act. In Elizabeth Jennings's case, the verdict arrives with the kind of phrasing that signals the court's desire to sound sensible, a wholesome result, an outcome that will supposedly restore balance without disturbing the larger order of the city. The words are calm, almost soothing, as if the law is doing a public service by being measured. But measured is not the same as just. The jury finds for Elizabeth. The company is made to answer, at least in part, for what it did. Damages are awarded, costs assigned. The court, through its procedures, is forced to admit something important. A passenger who behaves properly and pays her fare cannot be treated as disposable simply because of race. A streetcar company that holds itself out to the public must be restrained by duties to that public. This is the official meaning of the verdict. It is the meaning the city will later prefer to remember. The system worked, the wrong was corrected, progress was made. The lived meaning is more complicated. Elizabeth's body does not feel wholesome in the wake of public violence. No verdict reaches backward into that Sunday morning and prevents hands from seizing her. No sum of money erases the moment the car's doorway became a threshold of humiliation. The court's language does not restore what was taken. It only recognizes that something was taken and offers compensation in the only language it is trained to use. Money is not dignity, it is an admission. The number attached to her case is not large enough to look like punishment. It is designed to look reasonable enough that the court can claim balance without unsettling the city's commercial interests. It is an amount that acknowledges injury but does not threaten the company's existence. The verdict is a correction, not a revolution. The court chooses a remedy that can be absorbed. This is how institutions concede without surrendering. They allow a single case to be won so that the system can appear fair, and then they rely on inertia to prevent deeper change. The defense can tell itself that it lost on a technicality. The company can tell itself it merely needs better rules, better training, better phrasing, more careful ways to exclude without leaving stains on the record. The city can tell itself that one verdict proves the whole system is capable of justice. Elizabeth cannot afford such comfort. To bring the case, she had to step into public exposure. She had to accept that her character would be examined. She had to endure the transformation of her experience into testimony, then into argument, then into a judge's instructions and a jury's deliberation. She had to let strangers decide in private whether her humiliation counted. Now the verdict declares that it counted. That is something. But it is not everything. The deeper question remains, will the companies comply beyond this file? Will conductors treat the verdict as a boundary they cannot cross? Or will they treat it as an exception that applies only when a family has resources, lawyers, witnesses, and the stamina to turn humiliation into litigation? Because the verdict, however significant, does not automatically rewrite custom. Custom is not changed by a single piece of paper. Custom is changed when thousands of small decisions begin to align with that paper. And in New York, the small decisions are still being made by conductors on platforms, by passengers who demand comfort, by policemen who stand beside authority rather than against it. The official court record can say the company was wrong. The street can still behave as if the company is right. In the days after the verdict, the city's public voices interpret the outcome according to their needs. Some newspapers praise the decision as a sign of fairness, a confirmation that the rule of law can manage social tensions. They may frame it as evidence of northern virtue, proof that New York is not like the South, proof that prejudice can be corrected without upheaval. Other papers, more hostile, may warn that such verdicts invite disorder, implying that allowing black riders equal access will provoke conflict. This is a familiar inversion. The violence of exclusion is treated as order, and the demand for equality is treated as disruption. The company itself must decide how to speak. If it protests too loudly, it looks cruel. If it accepts the verdict quietly, it can minimize attention. The safest posture for the institution is administrative compliance without moral admission. Pay the damages, adjust language, preserve control. This is the atmosphere in which Elizabeth lives after being declared right. The law may have validated her claim, but the city's social order does not automatically concede. There is also the private aftermath, the part the archive rarely captures. To win a case is not to be released from what happened. It is, in some ways, to be permanently linked to it. Elizabeth's name becomes attached to the incident. Her life becomes searchable through this event. The victory places her under a different kind of light. She is now a symbol for those who need symbols. But being a symbol is a weight. It means strangers will tell your story in their own tone. It means your experience can be turned into moral lesson, political tool, or civic ornament. The verdict offers recognition, but it also fixes her in place as the woman who was ejected, even as she tries to live beyond that doorway. There is a subtle violence in this too, the way institutions allow a person to be remembered only at the moment they were harmed. And yet, the victory is not hollow. It is not cosmetic. It is a breach in the wall, small but real. It establishes that a streetcar company cannot claim absolute discretion. It suggests that private policy has limits when it serves the public. It provides a reference point for future challenges. It gives language to the community, not merely outrage, but precedent. This is the paradox of legal victories in hostile systems. They are both insufficient and essential. The court's decision converts Elizabeth's humiliation into a lesson the law can repeat. It becomes something that can be cited in future disputes, something that can be invoked when another conductor claims he may exclude at will. In that sense, the verdict produces a new kind of weapon, a piece of official paper that says, in effect, the company's rules are not sovereign. But paper does not enforce itself. The community knows this. They have seen laws ignored before. They have seen rights recognized in theory and denied in practice. A verdict is not the end of struggle. It is a tool for the next stage. For Elizabeth, the immediate moment after the verdict is shadowed by exhaustion. The court can declare her a rightful passenger, but it cannot guarantee that the next platform will be safe. It cannot promise that the next conductor will respect the file. It cannot promise that the next policeman will stand for her rather than against her. The city's cruelty is often not in the dramatic act, but in the repetition. The way each day demands the same calculation, the same vigilance, the same readiness to be challenged. Still, something has shifted. The verdict makes it harder for the city to pretend the policy is unquestionable. It forces a small adjustment in the city's moral grammar. A new sentence exists now in the public record, that what happened to Elizabeth Jennings was not merely unpleasant, but wrong in the eyes of the court. The question is what that sentence will do when it leaves the courtroom. Will it move through the city like a new rule, altering conductors' decisions? Will it empower other black riders to refuse exclusion? Will it inspire organization, more cases, more pressure? Or will it be filed away as a curiosity, an isolated incident resolved with a modest sum, a story the city tells itself when it wants to appear fair? This is the price of being right in a system that is not built to honor you. You may win and still be required to keep fighting. You may be validated and still be vulnerable. You may be awarded damages and still carry the memory of hands pulling at your clothing as if your body were not your own. The verdict is wholesome in the court's phrasing because it restores order without challenging the deeper structure. But for Elizabeth and her community, the verdict is only the beginning of what must come next, the attempt to turn a single legal victory into actual freedom of movement, to force the city's rails, those private lines laid through public streets, to carry people, not as permissions granted and revoked at will. The file does not close, it changes shape. Part 8. After the verdict, the Legal Rights Association and the long campaign. A verdict is a document. A campaign is an infrastructure. After Elizabeth Jennings wins in court, the city's official life continues with its practiced calm. Streetcars still run. Conductors still collect fares. Policemen still patrol corners where commerce and movement converge. If you looked only at the schedules and the printed notices, you might think nothing has changed. Institutions prefer this appearance. They prefer reforms that do not look like disruption. But within Black New York, the verdict does not sit quietly on a shelf. It is treated as a tool, one that must be held, carried, and applied again and again until its meaning reaches the street. This is where the struggle becomes less dramatic and more relentless. The most difficult phase is not the lawsuit itself, but what follows, converting a legal win into a social fact. The official version of progress is always tidy. It likes a single turning point, a single courageous figure, a moment when injustice is corrected. It prefers to suggest that once the court speaks, society obeys. It makes for a clean civic story. The reality is slower. The reality is that companies do not surrender habits because a jury awards damages. They adapt. They look for narrower interpretations. They strengthen informal enforcement. They rely on fatigue, on the public's short attention span, on victims' limited resources, on the quiet fear that discourages repetition. Black New Yorkers understand that if they stop here, the verdict becomes a souvenir rather than a lever, so organization expands. The Legal Rights Association emerges in this period as a response to an obvious problem. Individual cases are too costly, too vulnerable, too dependent on a single person's endurance. If discrimination is systematic, the response must be systematic. It must involve coordination, fundraising, planned litigation, public pressure, and constant documentation. The association's work is not primarily dramatic. It is administrative, it is paper-heavy, and that is precisely why it can last. The atmosphere shifts from a single plaintiff's file to a shared archive. Meetings, minutes, lists of incidents, recommendations for counsel, and a steady flow of communications designed to keep the issue alive even when the city would prefer silence. The association's existence is itself a form of moral accusation. It says, without needing to shout, that the city's claim to fairness is not credible. If New York were truly a place of equal access, such an organization would be unnecessary. Its very formation is an indictment of the gap between law and life. The official response to such organization is often condescension. Reform-minded whites may praise the goal abstractly while urging patience, suggesting that time will solve it. Others may accuse the association of provoking conflict, as if the conflict were created by the complaint rather than by the exclusion. This is a familiar institutional defense. Treat resistance as the cause of tension, not the system that requires resistance in the first place. In meetings, the association's members return to the central practical question: how does one enforce a verdict on a moving platform? The court's decision does not ride the streetcar. It does not stand beside Elizabeth's successors when they step onto a car. Enforcement still depends on human discretion in the moment. The conductor decides whether to allow boarding. The passengers decide whether to support exclusion or protest it. The police decide whether to protect the rider's right or the company's policy. The system is a chain of decisions, and a single verdict breaks only one link. So the campaign becomes a method for applying pressure at multiple points in the chain. One part of the method is legal. Identify new incidents and bring cases that expand the principle. One verdict can be dismissed as anomaly. Several verdicts begin to look like pattern. A pattern begins to look like obligation. Another part is documentary. Ensure each incident is recorded with precision: date, time, location, company, conductor, witnesses. The goal is to deny the city plausible deniability. A city can dismiss rumors. It struggles to dismiss a ledger. Another part is social. Encourage respectable black riders, well-dressed, calm, clearly orderly, to board and thereby test the policy's boundaries. This tactic is morally complex. It uses respectability as a shield because the city is more likely to accept a claim of injury from those who fit its ideals. It is also an acknowledgement of injustice, that the city requires black people to prove they deserve rights. Yet the association's leadership understands that if they wait for the city to become morally ready, nothing will change. Readiness is a luxury that power rarely grants. Power yields when compelled. Thomas L. Jennings, Elizabeth's father, stands at the center of this organizational approach. He is not only the father of the plaintiff, he is part of the broader machinery of black civic life: church, mutual aid, reform circles, places where trust is built and strategy can be coordinated. He understands how to keep records. He understands the importance of formal structure. He understands that the city's institutions respect paper more than they respect black testimony, and so the response must produce paper relentlessly. The campaign also depends on a kind of disciplined courage that does not look heroic in official stories. It is the courage to repeat an action that has already proven dangerous, to board again, to refuse again, to accept again the risk of hands on the body, of public humiliation, of police intervention. This is where psychological tension becomes central. Each new incident is not only an external conflict, it is an internal calculation. A black rider approaching the streetcar platform must decide: is today the day I resist? Do I have the time? Do I have the strength? Will anyone witness? Will anyone help? If violence occurs, will anyone record it accurately? If the police are called, will the officer treat me as a citizen or as a nuisance? The archive does not capture the seconds in which these decisions are made. It captures only what happens after, if the incident becomes public. Most of the time, the decisions remain unrecorded. People turn away, they walk, they postpone their errands, they arrive late to work, they miss church, they choose survival. The association's purpose is to reduce the cost of resistance by making resistance collective. If a rider knows that an organization stands behind her, that witnesses will be gathered, counsel consulted, funds raised, then the platform becomes less isolated. It becomes less like a trap and more like a front line. Still, backlash is constant. The companies may respond with tightened internal instructions, conductors warned to be firm, to call police sooner, to avoid language that could be used against them in court. The city's white public may respond with hostility, treating black riders as provocateurs. Even sympathetic whites may retreat when the issue becomes inconvenient, urging quiet, urging compromise, urging gradualism, the polite language of delay. Delay is itself a tactic of power. Every month that passes without enforcement is another month in which segregation remains normal. The companies profit, the public adjusts, the excluded pay the cost in time and dignity. The campaign must therefore fight not only discrimination but forgetfulness. This is why the association keeps returning to print, to notices, statements, public meetings. Publicity is not just persuasion, it is preservation. It prevents the city from burying the issue. It keeps the contradiction visible. A city that calls itself modern but permits modern vehicles to function as moving segregated spaces. Over time, the campaign's effect is cumulative. It is not one dramatic victory but a grinding pressure that makes segregation more expensive. More lawsuits, more public scrutiny, more reputational risk, more uncertainty for companies that want to present themselves as respectable businesses. The companies may offer partial concessions, allowing some riders on some lines at some times, experimenting with designated cars, shifting enforcement to avoid legal exposure. These half measures are often framed as reasonable compromise. In reality, they are a form of containment, a way to preserve segregation while appearing responsive. For the association, partial concessions are both proof and provocation. Proof that pressure works. Provocation because partial access confirms that full access is being withheld by choice, not necessity. The atmosphere in these years is therefore one of ongoing tension. A city moving forward technologically while refusing to move forward morally. An archive filling with incidents that should not exist in a free state. A community repeatedly asked to prove, with documents and discipline, what it already knows in the body. Elizabeth Jennings' verdict remains a central reference point, but the campaign deliberately shifts focus away from her as an individual. That shift is important. It refuses the city's preference for a single exceptional story. It insists that the issue is not one woman's bravery, but a system's routine cruelty. By the end of this part, the case has become something larger than litigation. It has become a sustained effort to force the city to honor its own public promises in the places where those promises matter. On the street, on the platform, in the daily movement of ordinary lives. The law has spoken once. The campaign is now designed to make the city listen, repeatedly, until the official version and the lived reality can no longer be kept separate without openly lying. Part 9. Desegregation. Without applause. 1855 to 1861, 1865. In New York, change rarely announces itself with a single, clean proclamation. It arrives in fragments, quiet adjustments, altered routines, policies rewritten without apology, practices abandoned not because they are deemed immoral, but because they have become inconvenient to defend. After the Jennings verdict and the organizing that followed, the streetcar companies begin to shift. Not all at once, not consistently, and not in a way that makes the city proud of itself. The official record, where it exists, prefers to describe these shifts as sensible business decisions, as improvements in order, as accommodations made in the natural course of urban progress. It rarely presents them as moral surrender. The lived reality does not feel like surrender either. It feels like negotiation conducted under threat. One route changes before another. One conductor allows what another still denies. One company quietly instructs its men to avoid confrontations that might become lawsuits, while another doubles down, believing the street is still theirs to police. A rider boards on Monday without incident and is ejected on Tuesday from a different car by a different employee, acting as if the law never spoke. The rails are fixed in the street. The rules remain portable and selective. In the archives, this period is difficult to read cleanly because it resists neat chronology. Public notices appear, then disappear. Newspaper items mention new arrangements without stating what those arrangements are. Complaints are raised, then answered with vague language. Some accounts later insist that New York streetcars were desegregated by 1861, while other recollections place the completion later, closer to the end of the Civil War in 1865, as if done depends on which company you mean, which line you mean, which neighborhood you mean, and whose experience you treat as decisive. The official city likes a single date because a single date can be celebrated and filed. The lived city has no such luxury. For a black writer, desegregation is not a proclamation, it is a daily test. The most telling documents are often the most banal. A rule changed in a company manual, an internal instruction to conductors to avoid disturbance, a quiet decision to stop enforcing exclusion because enforcement has become expensive. These are not the language of conscience, they are the language of risk management. They do not say, "We were wrong." They say, "This is no longer worth the trouble." And trouble has a specific meaning now. Lawsuits, public scrutiny, and the growing presence of organized resistance capable of turning a single ejection into a case file. Still, even partial change carries weight. Each time a black passenger sits and the car moves forward, something subtle shifts in the city's choreography. Segregation depends on repetition. It depends on the public absorbing exclusion as normal. When exclusion becomes uncertain, when a black rider might remain, the certainty that powers segregation begins to weaken. But uncertainty is not freedom. Uncertainty is another kind of tension. A city that is half changed is a dangerous place because it lacks stable rules. When segregation is rigidly enforced, a black rider can at least predict the danger. When segregation is inconsistently enforced, the rider must remain vigilant at every boarding. One conductor may be permissive out of indifference. Another may be harsh out of principle. A third may decide based on the mood of the other passengers. The passenger is forced into constant calculation. Is this the day the car becomes hostile? Is this the day the police are called? Is this the day the crowd decides that my presence is an insult? The official version of this period frames change as gradual improvement, but gradual improvement is experienced by those harmed as prolonged exposure. By the late 1850s, the city's political air is thick with national conflict. The country is moving toward crisis. Arguments about slavery sharpen, and the North's moral self-image begins to harden in reaction to the South's demands. New York's white elites can condemn slavery while still practicing segregation. But the contradiction becomes more difficult to ignore as national debates intensify. At the same time, the city's economic ties to the South remain real, and racial hostility remains embedded in daily life. Moral positions shift in speeches faster than they shift on street corners. The streetcar, in this atmosphere, is both minor and symbolic. It is a small space, but it is a public space. It is not about grand ideology. It is about who is allowed to sit without permission. As companies begin to loosen enforcement, the official public language often avoids the word equality. It speaks of arrangements, regulations, quiet, avoidance of disturbances. It suggests the goal is harmony, not justice. Harmony becomes a way to erase the memory of coercion. The city can tell itself it has matured, that tensions have eased, that progress has occurred naturally, without having to name the violence that made the tension real in the first place. But black New Yorkers do not forget. They cannot, because their bodies carry the history that the official record tries to soften. Each partial gain is held carefully because it can be reversed in practice even if not in principle. Even after a company stops enforcing exclusion formally, a conductor may still try. Even after a court decision is known, a policeman may still side with the company out of habit. And even after a passenger is allowed to ride, the atmosphere inside the car can remain hostile. The stare, the deliberate silence, the shifting away, the muttered words that never appear in testimony because they are too common to record and too slippery to prove. This is the quiet cruelty of desegregation without applause. It is change that offers no confession, no acknowledgement, no collective shame, only an altered routine that leaves the victims carrying the memory alone. When the Civil War begins in 1861, the city's official priorities become consumed by preservation of the Union, by recruitment, by riots of opinion, and, later, riots of bodies. In this national crisis, local segregation in streetcars can be treated as a lesser issue, another reason why a single clean date is deceptive. The war can accelerate moral posturing while also exposing how shallow moral claims can be when economic fear and racial resentment flare. If, as some later accounts suggest, streetcar desegregation is considered complete by 1861, It is a completion written in the language of institutions, policies adjusted, enforcement relaxed, fewer recorded incidents. But complete on paper does not necessarily mean complete in experience. A black rider may still feel the old danger in the new arrangement, because danger is not only policy, it is attitude. The system changes shape, and the violence does not always vanish. It becomes quieter, more private, harder to litigate. If, alternatively, other recollections place the final dismantling of segregated practice closer to 1865, then the war years represent not closure, but continuation. A long, uneven fade-out of open exclusion, with the last pockets of resistance clinging to custom until the broader national shift makes that custom harder to defend publicly. Either way, the key fact remains: the change is not celebrated in proportion to its significance. There is no civic ceremony for the day a black passenger sits without being dragged. There is no official mourning for the years when she could not. The archive reflects this imbalance. It is easier to find company announcements about routes than to find the inner life of a rider deciding whether to board. It is easier to locate an editorial praising order than to locate the silence of a woman who has learned not to argue in public because arguing invites hands. And yet, in this period, the city is altered by those silences and those decisions. Each time a rider boards and remains, the public is forced, if only for a moment, to adjust its sense of what is normal. That adjustment is the true work of desegregation, not the paperwork, but the slow rewriting of the street's assumptions. By the end of this part, New York has moved toward a new practical reality. Black passengers can increasingly ride without formal exclusion. The official story will later summarize this as progress. The lived story knows the cost: years of confrontation, organization, repeated risk, and a victory so gradual that it can be mistaken for inevitability. But nothing about it was inevitable. It happened because people like Elizabeth Jennings and those who rallied around her refused to let the city's private rules masquerade as law, and because they understood that the most punishing form of segregation is the one that feels normal, until someone insists, again, that normal is not the same as right. Part 10. What her name preserves, what the archive cannot. In the official imagination, history ends when the law speaks and the practice changes. A court verdict is entered, a policy shifts, a line is drawn under the event, and the city moves on. This is how institutions prefer to remember themselves, as capable of correction, capable of progress, capable of justice when properly petitioned. But Elizabeth Jennings's story does not end cleanly, because lives do not end where case files end. They continue in the altered landscape the file helped shape, a landscape still uneven, still capable of relapse, still governed by habits that do not surrender easily. What remains of Elizabeth in the record after the streetcar case is often quieter and more ordinary. An educator, a woman within a community, a life that does not always appear in the archives with the clarity that the conflict did. The archive, by its nature, is attracted to rupture. It records harm more readily than it records peace. It preserves the moments when power and resistance collide because those moments produce paper: complaints, verdicts, editorials, minutes, signatures. This creates a second injustice, subtler than the first. A person becomes legible to posterity primarily at the moment she was humiliated. Elizabeth's name survives in part because she was forced into a public confrontation. The city's system put her in the position of becoming evidence. It made her a case before it allowed her to be remembered as a citizen. In later years, she continues as an educator in Black New York, working within the long tradition of building institutions when the larger society refuses inclusion. Teaching is not separate from the struggle. It is another front. It is the work of preparing children to live within a system that will test their legitimacy and preparing them to respond without surrendering their dignity. Education is how communities create continuity in the face of official amnesia. Yet the archive does not always treat this work as dramatic. There is no single verdict for the daily act of teaching. There is no headline for the slow construction of resilience. The paperwork that remains, school records, association notes, occasional mentions, often lacks the emotional density of the streetcar incident. It does not show the weight carried by a person who has been made into a public symbol and must then return to ordinary life. In the official story, she won. In lived reality, winning is not a state. It is a continuous negotiation with a society that can accept your rights in principle while resisting your presence in practice. Even when streetcar desegregation becomes more established, The deeper architecture of racial hierarchy remains intact. Access to one public convenience does not equal access to the full city. Housing segregation tightens. Employment opportunities remain constrained. Schools remain unequal. Policing remains biased. The right to ride does not immunize a black person from being treated as suspect. The city can permit a seat while still denying belonging. This is why the moral meaning of the case cannot be confined to transportation. It is about what public space is and who is permitted to occupy it without asking permission. Over time, Elizabeth's name enters a different kind of official memory: commemoration. Plaques, institutional references, public history projects, these are forms of civic acknowledgement that often arrive long after the danger has passed, when it is safe for the city to praise what it once resisted. Commemoration can be sincere. It can also be sanitizing. It can turn a living conflict into a neat moral lesson with a clear hero, a clear villain, and a clear ending. But the case file does not support a neat ending. The file shows a city that had to be compelled, a company that did not voluntarily reform, a police force that served as reinforcement for exclusion, a public that could watch a woman being removed and treated as routine, a court system that could quantify her injury in a small sum and call the result wholesome, as if moderation were the same thing as moral clarity. And the file also shows something else: the relentless effort required to force recognition from an indifferent system. Meetings, minutes, petitions, trials, repeated incidents, the slow grind of public insistence. If the city now claims Elizabeth as a symbol of progress, it must also accept what her story says about the city's comfort with humiliation. Otherwise, commemoration becomes a way of congratulating itself for correcting a wrong while refusing to examine how naturally it committed that wrong. This is where the archive both helps and fails. It helps because it preserves the skeleton of events, dates, locations, names, legal outcomes. It allows the public to say, with certainty, that something happened. It prevents complete denial. It provides a platform for later generations to argue, to teach, to remember. But it fails because it cannot fully contain the interior cost. It cannot reproduce the feeling of being seized and pulled in front of strangers. It cannot preserve the internal calculation that preceded the refusal, the knowledge that resisting would escalate, the knowledge that compliance would confirm the city's judgment, the fear of police, the fear of being labeled the problem. It cannot preserve the private aftermath, the nights when sleep returns unevenly, when the body replays the moment of force, when the mind reviews every decision and wonders whether a different choice would have spared humiliation. Official documents rarely record fear with accuracy. They record actions and outcomes. They do not record silence. And yet silence is one of the most important facts of this story. The silence of witnesses who did not intervene. The silence of passengers who accepted exclusion as normal. The silence of institutions that preferred quiet streets to equal rights. Silence is how systems endure. It is how injustice becomes background noise. Elizabeth's refusal is significant not only because it produced a legal victory, but because it disrupted that silence. It forced the city to speak. It forced it to write. It forced it to reveal the logic it preferred to keep unexamined. The horror in this history is not supernatural. It is procedural. It is the ordinary way power operates, privately, routinely, with the confidence that no one will risk public conflict to challenge it. It is the conductor's calm certainty, the policeman's alignment, the company's policy phrased as comfort, the court's conversion of injury into a number, the public's quick return to business. In the present, the streetcar is gone, replaced by other systems of movement and access. But the logic that governed that platform is not gone. It survives wherever policy is used to deny service without admitting discrimination, wherever private rules are enforced like law, wherever public space is treated as a privilege rather than a right. Elizabeth Jennings Graham's name, preserved across time, stands as proof that a single person can force a system to expose itself. But her name also exposes the darker truth, that systems rarely correct themselves until someone is willing to endure the cost of refusal. We end with the file open, not because the past is unresolved in its facts, but because its pattern persists. A woman boards a public vehicle. She pays. She claims her right to move. The system asks, silently and without embarrassment, whether she has permission to exist there. The question that remains is not what she did in 1854. The question is what we recognize today, what exclusions we still call policy, what humiliations we still call order, and whose bodies are still being asked quietly to leave, 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 quietly